Further hearing in the appeal, Spiller and Nobber against Joseph and others.
Lord, I ask for Lordship's indulgence. I've already asked Mr. Bennett just for 2 minutes to correct one small error that I made yesterday.
Yes.
In Kemsley and Foote, I took your Lordships to a passage on page 357. This is tab 19 of volume 1. And I erroneously said that the paragraph at the bottom, starting one further matter on which, that the first part of that paragraph was dealing with justification, and then he goes on to deal with fair comment. Having reread it overnight, I'm quite sure I'm wrong about that. The entire paragraph is dealing with fair comment. The use of the word justify in those opening sentences is simply means proving the facts relied on for fair comment. It's a very small point. If your Lordships want to see where the Section 5 justification problem is conveniently dealt with, it's in the Porter Committee report. In tab 43 of volume 2, and your Lordships will find the rather harsh old common law rule set out in paragraph 79, whereby you had to prove every individual discrete libel, however minor it might be in comparison to the others. That's paragraph 79, and you'll see the recommendation, which becomes section 5, is in the concluding paragraph of that section, paragraph 82. Where I was wrong was to suggest that Lord Porter was dealing with the justification problem at the bottom of 355. He wasn't. He was dealing always with fair comment, and you Lordships can see that if one goes back to the beginning of the case. It's clear that the issue is entirely about fair comment. One sees that on the previous page, 354, where about 10 lines up from the bottom, it says the question for your Lordship's decision is therefore whether a plea of fair comment is permissible. In this case, it's entirely concerned with fair comment, and I was wrong to introduce justification in relation to that passage.
Yes, because he says at 354, he says it is not, as I understood, contended the words contained in that article fact and not comment.
Yes.
And the whole thing was about.
Indeed, Lord, and I thought I was making a mistake.
Yes, thank you.
My Lord, my submissions will fall into 4 parts. The first is that the comment in issue cannot be defensible as fair comment because it is construed as comment by reason of the false fact setting the words complained of, that being the false quotation attributed to the first claimant.
Sorry, could you just say that again? It can't be...
The defence of fair comment cannot get off of the starting block because the comment which the defendants rely upon is construed as such or becomes comment by reason of its juxtaposition with the false fact set out in the words complained of.
Would you say only by reason of its juxtaposition?
Either would apply, by reason of or only by reason of.
Yes.
My second set of submissions, which are in the alternative, support Lord Nichols in his 4th proposition as set out in Chang. It rejects the interpretation put upon Section 6 by Mr. Price on behalf of the defendants. And lastly, even if the claimants are wrong on that, when one looks at the facts in issue on this case, there was not sufficient reference to them, such as to make the fair comment defence viable. And the third part of my submissions will deal with various statements made by Mr. Price and Mr. Caldecott yesterday. And in particular, I intend to deal with Mr. Caldecott's point that where a fair comment defence fails because a fact has not been set out in the words complained of, that the claimant would unjustly be vindicated in his reputation.
You can have that one again.
I'm so sorry, my lord. If I can just put it this way, the third category will deal with statements, respond to statements made by Mr. Caldecott and Mr. Price. But most importantly, the assertion made by Mr. Caldecott that where a commentator has made a comment but has not set out the fact upon which the comment is made, if it were to be the case that the fair comment defence therefore failed because of the exclusion of that comment, Mr. Caldecott's position would be that therefore the claimant might improperly vindicate his reputation. And we say that isn't the case when one's considering the defence of fair comment, because of course the fact which isn't set out in the words complained of, it may not necessarily justify the allegation which the defendant is making. And my fourth set of submissions will go to that.
I've had some difficulty with this concept of vindication of reputation, because ex hypothesi, if fair comment has to come into play, it's on the basis that a statement has been made which is defamatory.
Yes, and in order for the claimant, there are two possible defences.
Yes.
There is the defence of justification.
Yes.
If the words complained of can be justified, that is, they are substantially true, the defendant will stop the claimant, quite rightly, from vindicating his reputation. But if one takes Mr. Caldecott's example, it's quite possible that the allegation concerned of the comment, for instance, would allege that an MP was racist, whereas the fact on which the comment was being made was in fact an anti-immigration speech. In that instance, the defendant would not be able to justify the allegation that the MP was a racist as being true. Similarly, the defendant could not fall back on the fair comment defence because it hadn't set out in the words complained of the basis for the comment, and that was that there had been an anti-immigration speech. In either scenario, the claimant does not unjustly achieve vindication. If fair comment's pleaded, the claimant does not unjustly gain vindication because of the exclusion of the fact. Because if the fact is merely that he'd made, for instance, an anti-immigration speech, he deserves justly to be vindicated. The only time at which a claimant does not deserve to be vindicated is when the allegation complained of is in fact substantially true, which is where the justification defence comes into play. Well, I'll develop that more fully during my submissions, but the fourth part of my submissions will take you to the relevant case law. And I will rely on just three cases. Kemsley in the Court of Appeal, and it has to be borne in mind that really it was the Court of Appeal decision which was the landmark decision which specified that in certain circumstances facts don't have to be set out in the words complained of in order for the fair comment defence to succeed. And then, again, a return trip, I'm afraid, to Kemsley in the House of Lords. And finally, I'll be going to the Privy Council case of J.P. Jeyaratnam against Go Kok Gok Chong. where under Section 9 of the Singaporean Act of Defamation is identical to the Section 6 provision that this court is looking at, just to see how in practical terms Section 6 or Section 9 or the words in Section 6 were applied in that case. My Lord, underpinning my submission will be that the defence of fair comment can be summarised in this way. It defends honest comment which has been fairly stated.
Honest comment which has been fairly stated.
Yes, my Lord.
What's that mean?
It means that there are two elements to this defence. The main criterion which the court has focused on thus far is that it defends comment which any honest man could make. Now that brings about a risk of unfairness, because if comment is published without the underpinning fact on which the comment is based, a reader who is deemed to be a reasonable person will assume that there is a proper factual basis for that comment. When in fact, given the range which the fair comment defence traverses, the ranges of opinions it protects, the comment, which we must remember would be a defamatory comment, a defamatory accusation, will in fact be given credence by the exclusion of the fact on which it's based. And really, we say this is where Lord Nichols's fourth provision puts the fair into fair comment. Because whilst on the one hand, the law gives a defendant what is referred to in the authorities as a licence to defame, because that licence is so wide-ranging, there needs to be an element of control such that the reasonable reader will be able to gauge the value of the comment for himself. And this is particularly important when one considers that Article 10 of the Human Rights Act provides a right not only to impart information, but to receive it. And one mustn't forget the third party, if one likes, in these proceedings, which isn't the interveners. It's the readers. If really the fair comment defence is there to advance the publication of information to society such that people can make reasoned conclusions on the basis of information given to them by the press or in a website or wherever, those conclusions based on reading that information need to be informed. And very often, where there is no prior information known to the reader about the matters in issue, the reader, on the one hand, might be said to be left in the dark. But on the other hand, given that the reader is a reasonable person who is likely to assume that the commentator is behaving fairly, the reader will conclude that the comment is well based when in fact it isn't. So we say that it's not just about the honesty of the commentator, it's about the fairness with which the commentator makes his comment, such as to give readers a proper opportunity to gauge how well it's based on the supporting facts.
Could you give me a concrete example of a sort of one which is all right in your test and one which is not fairly performed? I'm not quite following what we're talking about.
Well, for instance, I'll take Mr. Caldecott's example of a comment is published which accuses an MP of making a racist speech. And no supporting facts are set out. The reasonable reader would conclude that the MP was a racist, of the sort who would join the British National Party and believes in the racial superiority of one race over another. Most likely, for instance, in this context, the white race over any other race. Now, that would be an extremely damaging defamation. But consider whether that comment was made on the basis of a speech which just set out in strong terms why the MP wanted a stronger immigration policy. Now, given the range of facts upon which a defendant might rely...
So the statement in this second alternative is what?
Pardon me, my lord.
Was this a second version of the statement? You said suppose that it was made by reference to...
Well, no, just consider a bare statement. It just says an MP is racist.
Well, you said admitted.
And if you like, in the commentator's mind, the commentator's thinking, well, I think he's racist because he made that speech saying we need stronger immigration policies. Now, the commentator, as an honest person, can reach that conclusion from that fact because he only has to make a comment that's honest. But by not including the fact about the anti-immigration speech, he is damaging the claimant unnecessarily, unjustly, and without really furthering the public interest in the freedom of speech, because he's not giving the public the full information on which the public can gauge the value of the comment, because the man, the claimant being defamed, is being defamed as an out-and-out racist, when in fact the basis for that is a very weak one.
I mean, are we assuming that all that is said is Mr. X MP is a racist?
Yes.
Now, is that a comment?
Well, this is the great problem.
Oh, that is the problem. It's the question.
It's the example that Mr. Caldecott did give, I may say so. And what I'm trying to demonstrate is that this is why comment needs to be not only honest, but fair, because one can see how when a crucial fact is excluded, that unfairness results.
I thought it only counts a comment if you actually have a fact upon which you're commenting, and it's either a fact which is stated expressly or it is something which is implied from the comment. That's what Keynes is all about.
The strange thing about, the peculiar thing about this defence is that naked or bare comment is very rarely comes into play in it. It's usually an inference drawn from fact. It's, if you like, a factual deduction. True comment or naked comment only really occurs when someone is, for instance, commenting on a play or a book, or perhaps, as in the Kemsley case, on the existence of newspapers, something that's put forward to the public for judgment. In most other cases, I think on most of the authorities which are before you, it's an inference from fact. My Lord, it's for that reason we say where a fact is set out in the words complained of, which is not true, and by the inclusion of that untrue fact, something which, just looking at the page in question, something that was a statement of fact becomes a comment, that means that the defendant cannot get his fair comment defence off the starting block. And that is the defendant's case on these facts. My Lord...
Could I just put down a marker
Yes.
about the application of what you're saying to this case, and in particular, all the reliance on the fact that there's an S wrongly included,
Yes.
or said to be wrongly included. Because if, when you look at the substance of what was actually said about the contractual obligations, or the force of the contract or contracts. And if you reach the conclusion that what was actually said was not specifically looking at a specific contract, but was a general statement about the kind of contract that the defendants entered into.
We would say on the facts of this case that the defendant cannot wriggle out of the fact of the misquotation on that basis, because really of the fact that it's not just a fact asserted, it's fabricated evidence.
Well, fabricated is colourable. It's not common ground that it was fabricated. It's
Well,
common ground
my
that it was
lord-
inaccurate, isn't that right?
Well, my lord, if one looks at the original email and compares it with the words as published on the website, they are different.
Well, the words purport to be a direct quote from the email. They plainly are not a direct quote.
No, they're not. And this hasn't happened because there was a slip of a pen on the part of the defendant. There has been a deliberate act where an email in one form was changed, amended, and put in a different form, such as to cause it to say something fundamentally different from what it originally said.
Yes, well, it's the fundamentally different that at the moment I'm not persuaded of.
Well,
that may be for another day. But I just wanted to put down a marker about that, so far as I'm concerned. That when you actually look at what was being said about whether the contracts are binding or not, it seemed to me that what was being alleged was a generic statement about these kind of contracts, albeit that there was no S on the word contract where it appeared in the email.
yes, my lord, but and I realise you've put down that marker.
Yes.
But if I might expand on this to a limited degree in the basis that the other members of the court, the other justices, might not have reached that conclusion.
It might very well not.
It's might I take you to the emails in issue, which are in the Appendix 2, I believe.
Page 13 of the Statements of Facts and Issues, page
Page
3.
1 and 3. Now, if I could take you to tab 1 to start with, which is when the first defendant kicks off the argument. It's page 1 of Appendix 2.
Yeah, right. Yes.
You'll see there, this is expressed in strong terms. Craig, it appears you've taken the booking directly with BBIS. We'll be instructing our legal team to deal with this. It will also be discussing this with the Musicians' Union, as it does appear that aside from having no commitment to those that give you work, you're also not able to abide by the terms of your contract. Now the contract, the terms of the contract is set out, and it's a re-engagement term between an agent and an artist.
Yes.
Forthwith, we'll no longer be working with you because you're not professional enough to be in our portfolio. Now that's something the reader is given no indication of in the words complained of. And there's even no indication that this is the real subject matter, a private contractual dispute between an agent and an artist over one clause in a contract.
In a standard form contract, we can only work with professional artists who can accept our terms and conditions.
Yes.
Yes.
Yes, but the reader's given no impression of that. And then when one looks at the next document, tab 2, which is the email, and I do choose my words carefully, which has been deliberately misquoted in the words complained of. This wasn't an accident. Hi, Jason. And again, this responds in strong terms, and Mr. Price can make much of the content of this email in a defence of justification. But we say, for the purposes of the fair comment defence, the content of this email isn't referred to in any meaningful sense in the words complained of.
Well, let's just look at it. The second paragraph. You came to Jason after viewing the quality of our show. Your contract is merely a formality and holds no water in legal terms. Now, that could be a reference to your form of contract, your standard contract, couldn't it? Not this contract.
Well, it must be the contract between the claimant and the agent, the defendant. But it's what it isn't saying. I'm sorry to labour this point. What it isn't saying is we don't honour contracts at all. We don't respect contracts, which is the foundation of the comment as set out in the words complained of. And it's interesting to note that in its defence, the defendants say that they refer to the whole of this contract. Well, we say it's fundamentally unjust and something that can be determined at the interim stage. On the one hand, the defendant sets out a very harmful misquotation on the website, which in effect, and I'll use the word again, deliberately creates a false confession made by the first defendant,
Well,
first claimant.
Go back to the second paragraph. That does not hold any legal value anymore. That seems a very general statement.
Yes, well, this is, on both sides, there is a strong argument and strong language is being used by non-lawyers. And this is the sort of language you might expect in a spat such as this. I don't seek to diminish the seriousness of that, but what I do seek to say that is fundamentally different from what found its way into the email, when great credence was added to the allegations in the email, specifically the comment, by the fact that, in effect, the first defendant was waving in his hand a confession supposedly given by Craig Joseph, which suggested that people who were reading the website, who were potential bookers of the ad, the Gillettes for weddings, confirmations and other celebrations, saying to them, your booking is in danger, not because we have had a fallout over this re-engagement term, but because Craig Joseph has said to me in writing, here it is, see what you think, contracts hold no water in legal terms.
Well, you have to read what's said in its entirety, and it's important, isn't it, that that part of the email is preceded by a sentence starting, however, following a breach of contract. So they're talking about a particular breach of contract. Now, and if the word your had appeared before contracts, would you be complaining? In other words, if what was quoted included the word your, which does appear in the original, true, the plural is there, but if it had said your contracts, following a breach of contract, then the statement, your contracts hold no water in legal terms.
No, because that would be a proper summary of this email. Because, pardon me, the claimant is saying in this email, your contract, that is the defendant-claimant contract, holds no water in legal terms. He doesn't take it further than that.
So it's a bit of the facts I don't quite follow. I mean, do I understand what this really was there was a contract whereby 1311, or whatever they were called, were the promoters of of the Gillettes, or whatever they're called. Is that right?
If I can sketch out the brief factual background, it's not all agreed, but I think it gives you the context. The claimants went on to the second defendant's books, and the second defendant was one of several agents who finds them work for weddings and so forth. One of the bookings was for a restaurant called Beebis. The Gillettes turned up and performed at Beebis. It went extremely well. But at the end of it, the woman who worked for Beebis said, we really like you, but we won't go through the second defendant's agency again because it's expressed in very forthright language. We really don't like the first defendant. Then the BBIS contacted the claimants and said, we want you to play on New Year's Eve. And the booking was made directly between the defendants and BBIS restaurant. This was despite the fact there was a re-engagement clause within the contract between the claimants and the second defendant, which said if you go back to a venue which you've been introduced by the defendant within 12 months, well, it says, in fact, you can't go back unless you go through the agency.
Was there any kind of contract between 1311 and BBIS? Because I think
There must have been.
There must have
must have been.
Because there's some suggestion that they too were in breach of the contract, isn't that right? Because,
Well, yes.
by
it's-
re-engaging.
Yes, pardon me. There were contracts sent at the time of the booking to BBIS and to the claimants. Both contracts set out the date for the booking and so on and so forth. Both contracts breached the re-engagement clause. So arguably BBIS had breached the clause, although no action was taken against BBIS. And also the claimants supposedly breached the clause. So that puts this, if I can call it, spat into its context. And if one wants to identify the subject matter of this case, of these emails, of this dispute, it is a private contractual dispute between the claimants and their agent over a re-engagement term. There is not the slightest hint in any of this material, by which I'm talking about the emails, that contrary to what's suggested in the words complained of, that there is evidence to suggest the claimants will agree to turn up at a wedding and not honour the contract because they have no respect for contracts per se. We say there is a world of difference between what was alleged in the words complained of and the facts on which it's said to be based from the comments set out in the words complained of, which saying, don't contract with these guys, they will most likely not honour your contract. And one can imagine the damage that would cause to claimants in a situation such as this. My Lord, before leaving the email at page 3 of Appendix 2, it's notable that in the last full paragraph, there's a reference as follows. There is one outstanding show with you guys, August the 4th, 07. We will honour the show as we have all the other shows through your agency, providing you make sure the balance fee is in our account 2 weeks prior to the show date. Now this, my Lord, is pointing to the opposite direction from what is said in the false quotation. This is material which the defendant is supposedly relying on, which is saying that these people, the claimants, are actually, despite the spat, and I don't mean to underplay it, it's a serious argument between the defendants and the claimants. They're saying, however, we will still honour bookings. I emphasise that word because a booking in this context is taken to be a booking to turn up at a wedding or whatever. We will still honour bookings and we will still turn up to this wedding that's on our books.
We assume that the business about the balance fee was on being in 2 weeks before the show date was a term of the contract, an existing term of the contract.
Pardon me, my Lord?
Was it an existing term of the contract?
I can't answer that
Well, if it
question
weren't,
with
if it wasn't,
certainty, but I suspect...
it would be seeking to vary the contract rather than to perform it.
My Lord, that's a question I can't answer. But taking this email on its face, it's showing a commitment on behalf of the claimants to still turn up for this booking in the future, despite the fact there's been this falling out between the claimant and the defendants.
This is probably peripheral, isn't it? It's an issue, it seems to me, primarily an issue of whether the statement, which is a statement of fact, which includes the quotation, can or cannot be justified. Because you say this is a statement that no contractual obligations will be respected.
Yes.
The alternative argument is when you read in his context, it's not as wide as that. But that's the issue in justification, isn't it? What does this mean?
Yes.
But what we're concerned with basically here is whether or not there can be reliance to justify is the wrong word. Reliance for the purpose of fair comment on matters which were not expressly stated.
Well, I'm going to move on to that if you don't mind. But
yes.
my first point, which I'll stop labouring shortly, is that a defendant cannot pray in aid a fair comment defence where the comment he relies on is only comment by reason of the fact of its juxtaposition with a false fact. You can't pull yourself up by your own bootstraps by, in this case, not only putting in a false fact, but, and I'll use that word again, deliberately doing so.
If it's a false fact, then you'll win on justification. If you lose on justification, it will mean that it's not a false fact.
It's not quite as simple as that. The defence advanced a fair comment as a defence to the whole of the words complained of. It's what I'm dealing with at the moment is that you can't have a situation where someone is able to plead a fair comment defence if the comment, the very foundation of the defence, only got there by reason of including a false fact in the words complained of.
Well, isn't this what Section 6 is all about? Insofar as you're basing your comment on something you've included in the publication, does that bit of the publication which is erroneous really destroy the basis of the comment you've made or not?
Yes.
And if you can still justify the comment you've made on what's left in what you've said, then you're all right. But if the inaccuracy in what you've said really destroys the foundation for your comment, you're not all right.
Yes, it becomes, have the facts been fairly stated? I want to make one more point, if you'll bear with me, before I move on to considering Cheng and Section 6. And this point derives from the fact that the email has been concocted or fabricated by the defendants. And it's for this reason, I say my argument that I've just set out about fair comment defence shouldn't get off the ground if the comment is based on a false fact, applies all the more so if the false fact which gave rise to the comment had been knowingly concocted by the defendant. After all, the test in this case is you're looking as to whether any honest man could make...
Well, this goes straight into malice, doesn't it? Knowing concoction of the basis of your comment is going to take you outside fair comment because it won't be fair, it will be malicious.
My lord, it will undoubtedly support the claimants greatly in proving malice in this case.
But this is not what we're in this court to look at.
Well, my lord, if you just bear with me while I just make this point. The test, and it is an objective test at this stage, is that no honest man could make the comment. We say the defendant cannot get round this by inventing the fact on which the honest man is taken to comment. If Mr. Price's theory is correct, that the obliqueless reference to facts of which the reader will know nothing is enough to rescue this defence of fair comment, then this court must be aware of a potentially unjust lacuna. It would be unjust to invent a fact which gives rise to the comment, which sets out, as here, compelling evidence as to why the inference contained in the comment is a proper and well-founded one. So on the one hand, you have the interpretation of the words here, which is an objective interpretation. The comment is projected as a compelling one by reason of the inclusion of that false quotation. Now, if you allow that to happen, you most definitely ought not to allow a system where the obliquous reference to other facts is allowed to rescue the defence. And of course, all we have here in the words complained of, apart from the false quotation, is a reference to a breach of contract. The reason for this is that once the defendant gets past the stage where he's proved the comment is comment, he doesn't have to introduce other compelling evidence of the nature of the email. Because of the width of the honest person test, he can introduce thoroughly uncompelling evidence of which the reader will know nothing in order for the defence to succeed. And that's why we say at this stage, before considering chain in section 6, some thought has to be given to this potential lacuna. You cannot, on the one hand, set out a compelling case for the allegation in issue or the comment in the words complained of, find that evidence is in fact untrue, and then because of the width of the honest person test, bringing pretty much any information in, which will be far less compelling, on which an honest person still could supposedly reach the comment in issue. My Lord, before moving on, Mr. Price made a reference to the free market of ideas. It's noticeable that in this case, the defendants had a monopoly on the information in issue. They controlled the website. There was no way in which the claimants could fight back, except by threatening and then issuing legal proceedings. And it's one of those cases where the reader had no way of knowing the true position. That is, that this was a private contractual dispute. And it's notable, there's some talk of the defence of fair comment ought to be weakened and not give claimants so much protection because of the fact of the internet. On the facts of this case, the internet, the website, was used as a weapon against the claimants to spread, we say, false and defamatory allegations against them. My Lord, I'm now going to move
just before you do, could we just look again at the posting, the words of the posting, because I just or we can get it in the statement of facts and issues, just to take up as what I understood the position which was being adopted by Mr. Price yesterday. You've concentrated so far on the bit which is below, where it says what we say and so on.
Yes.
What about the bit above that, which is, because there we have, as I understand it, said to be no longer able to accept bookings as they are not professional enough to feature in our portfolio.
Yes.
Comment is said to be fact and have not been able to abide by the terms of their contract. He says that that's a fact.
Yes.
And the question one of the questions he raised, as I understood it yesterday, was whether or not that fact, that statement, was wide enough to allow in the landmark booking, for example.
Yes.
And so, in other words, he could justify that comment there by reference to the landmark booking and all the other background information.
Well, can I deal with this point about not professional enough? Mm-hmm. It's a fundamental tenet of libel law that one looks at all the words complained of. Mm-hmm. And that's not just the words that the claimant selects for complaint. It's really the whole publication. Now, looking at that paragraph where it says the Gillette's care of Craig Joseph are not professional enough to feature in our portfolio, the first notable point about that is that comment of itself isn't defamatory. It's not defamatory to say that someone is not professional enough to do something. It is defamatory to say that they're unprofessional. If I might give you this example, if a potential pupil applies to a chambers to become a trainee barrister and he or she is rejected because he or she is not seen as being good enough for the chambers, that doesn't give them a cause of action in libel. But what's particularly notable about this case is you can't isolate that reference to not professional enough from the false quotation, because it's the credence being given to that. The false quotation is really suggesting they're so unprofessional as to suggest they have no respect for contracts at all.
I mean, I'm just trying to understand.
Yes, my Lord.
You say that part has got to be tied in with the particular reference to the...
Yes, you can't start... It's a matter of analysis. It's very helpful to look at it sentence by sentence, paragraph by paragraph. But ultimately, you've got to read this in the sense it conveys as a whole.
I understood you said, well, the defendants say, well, this was a conclusion that they had drawn in the light of their experience, including, for example, the landmark incident.
Well, yes, that's what they say.
And is that not, supposing the thing had stopped there, would they be allowed to prove the landmark incident?
Well, yes. I mean, the claimants wouldn't have issued an action in libel there because it's really not.
So not because if you're not professional enough to feature, and you have not been able to abide by terms of the
suppose it says
contract.
not professional enough to feature, and the reader happened to know about the landmark incident, which occurred some 17 months before this incident blew up with the website, and the reader knew that roughly on the defendant's case, a week after the booking was made, that the claimants rang up to say, I'm sorry, we've got a double booking. If the reader saw that information and then saw the other part, that not professional enough, the reader would be in a position to gauge the value of the conclusion. And a claimant in that position wouldn't sue in libel at all because he'd go into a consultation with a barrister and they'd say, well, look, all right, it's not very nice for you to be defamed in this way, for it to be said you're not professional. But because they've set out this true fact in the words complained of, then you can't sue. The good thing for you as the claimant is at least the reader can see the basis for that conclusion and might think, well, that doesn't seem like a very good basis for reaching that conclusion or not. My Lord, I'm now going to move on to the case of Cheng and also consider Section 6 and as to whether Section 6 has any impact on the principle set out by Lord Nichols in the 4 or 5 tenets of fair comment. My Lord, the claimant's case is that there are insufficient facts set out in the words complained of, particularly given that the reader was taken in the wrong direction by the inclusion of the misquotation. And we also say this isn't a case in which it was impractical for the defendant to include some fuller reference to the facts underpinning the comment. That could have easily been done via the website of which the defendants had control. My Lord, turning to Section 6, which is at the front of your bundle 2 of authorities,
Sorry, what are we going to?
oh, pardon me, my Lord, Section 6 of the 52 Act.
Yes, sorry. No,
You probably know it off by heart, but if you'd like to look at it, it's
to go
at the front of bundle 2 of the authorities. Now, I can't give you a definitive interpretation of Section 6. In certain respects, it is confusing. At the very least, what it means is that I can't come before this court and say that because of the inclusion of one false fact, the fair comment necessarily fails. What it does mean is that it allows a fair comment defence to work, to succeed, if despite the inclusion of a false fact, the comment is still fair with regard to other facts or subject matter alluded to in the words complained of. My Lord, there's been a great focus on whether the defence is fair or honest comment. In fact, as I hope I made clear at the beginning of my submissions, there are elements of fairness and honesty in the defence. And we say, looking at the wording of the provision, in an action for libel or slander in respect of words consisting partly of allegations of fact and partly of expression of opinion, a defence of fair comment shall not fail by any reason that the truth of every allegation of fact is not proved, if the expression of opinion is fair comment, having regard to such of the facts alleged or referred to in the words complained of as are proved. Now we say that the focus here in Section 6 isn't so much on what a commentator might honestly think on the facts. It's what the reader might think in reading the words complained of. And we say section 6 is driving at ensuring that the comment is fairly set out in regard to what facts alleged or referred to are set out in the words complained of. We're not saying, section 6 is not saying you ignore the false words in the words complained of, and it has to be borne in mind that the court has to bear in mind what the reader would conclude from looking at the words complained of as a whole. And we say it would be very odd if section 6 meant, as Mr. Price contends, that despite the reader being led in the wrong direction by the false quotation set out in the website publication, that the defence could be rescued by the oblique reference to a breach of contract. The comment must be fair as it's set out on the page and as seen by the reader. What we say is that in this case it is not fair because the false information is not rescued in the eyes of the reader by the true information, which is information concerning the landmark breach of contract and the BB's breach of contract and the email. So just as I say that section 6 means that that I can't strike out the fair comment defence merely by saying it includes a false fact, Mr. Price, on the other hand, cannot come before you and say, well, the fair comment succeeds because there is just a reference. And I'd say a reference in the defendant's head because the reader wouldn't be aware of the reference to true facts which exist elsewhere.
Yes. The significance of section 6 depends upon what you're focusing on. Section 6 is there to sweep away an unsatisfactory technical rule.
Yes.
That if you have referred to a fact which is inaccurate, you're dead in the water as far as fair comment is concerned.
Yes.
That goes. Now, the more interesting bit, perhaps, is the second bit. Is section 6 purporting to do no more than set out the law as to what you need to establish in order to have a defence of fair comment? I.e., is section 6 saying it doesn't matter if you've referred to an inaccurate statement, provided that, putting that on one side, you have a good defence of fair comment?
Yes, it is saying that. And the question becomes...
Then the question becomes, what is the requirement of referring to
Yes. And
words which are not actually alleged?
Yes. The facts which the court thinks, the true facts which the court decides are permissible in the defence, need to be evaluated in comparison to the false fact. If I put it this way, if the balance tips in favour of the true facts, then the defence of fair comment still succeeds. And in doing that, you must look at the context of the words complained of and to what extent the reader would have been aware of what might be called the countervailing true facts. This is where the element of fairness comes in. And I'll be taking you to the case of J.B. Ratnam and Gokok Chong, where the Privy Council looked at a similar provision under the Singaporean statute. And in that case, there were false facts in the words complained of. But the Privy Council concluded that the true facts went to the pith or substance of the libel or the comment. Therefore, the fair comment defence survived. And also I'd rely on the case which you were taken to by Mr. Price, the case of Rath at paragraph 88, where Mr. Justice Tugendhat said in carrying out the process of evaluating the comment, bearing in mind section 6, that one should look at to what extent the false fact materially injured the claimant. And really this comes back to the balance. For instance, if the false fact materially injures the claimant by materially defaming him, can the true facts redress the balance?
If one just looks at this, I mean, do you accept that? I mean, as I understand it, you've concentrated on the bit, for this reason it may follow, which is a comment on what has immediately gone before, which you say is a false fact.
Yes.
Now, but at the same time, you seem to accept that somehow or other they would be entitled to prove all these other things, about landmark and so on and so forth.
It's my first submissions were really saying you cannot get out of the starting gate if the comment you're relying on is a comment because of its juxtaposition with a false fact. And in this case, you can see that's how this case is advanced by the defendant. The crux of the words complained of are the linking words, for this reason. For this reason refers back to the false quotation. And then after that, the conclusion is set out, which is an inference drawn from the quotation.
And you say that if the quotation, the false quotation is false, if the quotation is false, then they're not entitled to have a comment on that.
Yes, it stops there. It
stops there.
What I'm advancing now is an alternative case. If you're not with me on that, then we go on to consider the fair comment has got out of the starting block, and we're now considering whether the fair comment can succeed given what Lord Nichols said in Cheng and given the content of Section 6.
Yes. I mean, for this purpose, do we simply take out the sentence that begins Craig Joseph and ends 27307? And then ask the question, if that sentence wasn't there, would there be a viable defence of fair comment?
I see your point. This is the difficulty. You cannot rewrite what has been written. These words have been published. They've been read. It's a very if you like, over-technical exercise to go back and try and rewrite them. So I would say you don't do that because the defendant chose to put in this quotation into the words.
The choosing to put the misquotation muddies the waters. That goes to bona fides or
putting
malice.
his state of mind at.
You might
Just the
principle. You might have done it by accident.
Well, let's just say it's false, because perhaps if you say it's accidental, it goes in the other direction. But let's just say the fact is false. It's there. It can't be drawn in. The damage has been done. It's been read by the readers. It's a thoroughly academic exercise which has nothing to do with vindication and really nothing to do with the defendant's right to freedom of expression, to try and think about what would have been the case had these words been formulated in what would have been a fundamentally different way, given that the quotation really is at the crux of this publication.
Well, the court maybe is interested as a matter of principle with what the position would be if that sentence were not there. Because if you look at Section 6 of the 1952 Act, it's arguable that the last two lines spell out three propositions. For a defence of fair comment, you must first of all have facts alleged or referred to on which the comment is based. Secondly, those facts must be proved to be true. And then thirdly, the comment must be fair, i.e.
Yes.
And one issue that it seems to me arises fairly starkly here is what you need to do by way of reference to establish your base of fair comment. How much? You may be referring to something that's in the public domain. If it's only within your own bosom, because it's something that was said in an email to you or something that's developed out of your relationship with the claimant, how much do you have to say before you can rely upon that to found your comment?
Enough for the reader to gauge the value of the comment, to reach some sort of judgment.
So that's
of the gap between the fact
Yeah.
and the comment.
Yes, that's what Lord Nichols said, and one of the crucial issues of principle here is, was he right or wrong?
Yes, and that moves me on to my next proposition in support of Lord Nichols. Before I do so, one also has to bear in mind the credence given to these allegations set out on the website, because that's another fundamental feature of this case. It's just not an asserted fact. The reader is being told, this is my comment, this is my conclusion, this is the evidence on which I've reached it. I'll leave that point and move on to Lord Nichols, who in my submissions, I will support what he said in Cheng as being right as a matter of principle, and also right as a matter of summarising the English law. He said the comment must explicitly indicate at least...
Where are we going now?
I'm not going to...
Well, I'd like to. Could you?
Oh, pardon me. We've been to it a few times before. It is at bundle 2, in fact, towards the back, at tab 62.
Thank you very much.
Bundle 2, tab 62. And it is at page 782 of the report. And you'll see that he sets out the 5 objective limits of the fair comment defence. And really, the matters in issue today focus on the 4th of those, which is at paragraph 19 at the bottom of page 782, where he says, next, the comment must explicitly or implicitly indicate, at least in general terms, what are the facts on which the comment is being made. The reader or hearer should be in a position to judge for himself how far the comment was well-founded. Now, we say that isn't saying that the reader ought to be able to conclude whether, for instance, the comment is true or not. It's this test, we say, what Lord Nichols is saying, is that the reader ought to be able to gauge the value of the comment. There needs to be some appreciation of, if I call it the gap, between the comment, which will often be, if you like, a conclusion, between the comment and the fact on which it's based.
So how can a comment be true?
Well, it's, in nearly all the cases in the reports, it's usually a fact followed by a conclusion based on those facts. In those sorts of cases, you probably prove that the comment is actually true. And in this case is a good example of that, where there is a defence of justification as well in relation to the same words and broadly the same allegation as set out in the comment.
If I say of somebody he's a scoundrel, I say nothing more than that, I can presumably justify that by proving that he commits rapes and highway robberies and all kinds of things. That's because that's a fact. I mean, that's a justification of the thing. But it's not. He's a scoundrel. Just said out with nothing is not a comment on anything.
It becomes a comment. I think Lord Nichols gives the example of that at paragraph 17 when he quotes from the New South Wales case. To say that a man's conduct was dishonourable is not comment. It is a statement of fact. To say that he did certain things and his conduct was dishonourable is a statement of fact coupled with a comment. So it as always with libel, it's a highly fact-sensitive jurisdiction, and it depends on the words used and the context in which they're used.
But I mean, the comment...
I'm sorry. Sorry, I mean, that seems to me an extraordinary example, I must say. I mean, if the law of libel is really as completely irrational as that, it's about time Parliament did do something about it.
Pardon me, but which
The quotation from the New South Wales case, I mean, from Mr. Justice Ferguson. Words fail me.
Well, there you are. That's the example that Lord Nichols gives. It's perhaps a neat example. Perhaps better words could have been used. How a simple statement might be factual, but when it's presented with another fact, it becomes more obviously.
I concede that in some cases it is very difficult indeed to distinguish between what is a statement of fact and what is a comment. And your example about someone's a racist is quite a good example of one that's near the borderline. But to say that it depends simply on the whether an adjective or a on the order of words in the sentence, that does seem to me completely irrational. It really does.
I'm not saying that as a sign.
Well, you're just showing us what Mr. Justice Ferguson said.
Yes, and there are other examples
I
of
also
this.
have some difficulty in saying that attaching an adjective to a person is a statement of fact. It seems to me that if you say somebody is dishonourable, implicit there is that he has done certain things which would lead the reasonable person to comment that he is dishonourable.
Yes, and the reasonable reader to conclude that the statement was well-founded or reasonably well-founded.
Doesn't tell you much. You might say a man's dishonest.
Yes.
And that might be justified on the basis that he'd actually got on the tube without getting a ticket, or that he'd just been sent down for 20 years for fraud.
And this is where the fair element of the fair comment defence is important, because it takes account of that problem, where a defamatory statement is made without setting out what the comment, a defamatory comment is made without setting out what the comment is on. And to this extent, I think it's very important to look at three categories of, if you like, facts upon which someone might comment, which are set out in the case of Kemsley. I'm not going to go to that now, but if I might, just as a matter of principle, set out what we say those three categories are. The first category is what was dealt with directly in Kemsley, and that is where one is commenting on a play, a book, or a newspaper, or something similar, which is put before the public
These are three categories of what? Comment?
I'm going to set out three different types of situations in which one might have comment, and which in each case I'm going to argue that the reference to the underlying facts is different. At the very top of that list is the category which is discussed at some length in Kemsley, where one is, for instance, reviewing a book or a play, in reality, doesn't need to refer to facts at all. All one needs to do is refer to the fact of the existence of the book or the play and comment upon that fairly, which means, for instance, you can't misrepresent what the book was about. So you can make scathing comments about the author's ability to write the book, but you can't misrepresent, for instance, what the subject matter was. At this stage, and for the purposes of the fair comment defence, it's accepted that the reader doesn't need to know really any of the facts. It's likely, given that, for instance, a book review will be published either shortly before or shortly after a book is first published, it's almost certain that the reader won't have read the book for himself. And if it's a stinging review, it's probably almost certain that the reader won't go out and buy the book. This is a category of itself.
So far as that category is concerned, would one say, if the matter has been brought into the public domain, it is enough for the commentator to refer to what is readily available to the public?
Yes, and that's well settled by Kemsley and clearly makes sense. And if one were to think in in terms of the ordinary layperson about the defence of fair comment, one would think, well, that's obvious, isn't it? If someone puts on a play in the West End, then a critic's got the right to attend, dip his pen in gall, and lambast the play in the next morning's newspapers. And that's quite likely to have commercial effects, negative commercial effects upon the play, but so be it. The production company putting on the play has chosen to enter into that arena and has to take comment as it receives it. The second category, and in that case, it's really, these words subject matter come up in the case law. It's really all the commentator needs to do is say, here's the play, this is the book I'm commenting on, that is the subject matter.
So he's entitled to say it's badly written.
Yes, and that's clearly necessary for the public discourse. People have a right to be informed of that sort of information, and it will help them decide whether to buy the book or watch the play for themselves. I suppose one could say at least they have an opportunity to do so. But then the next category of facts which a commentator could rely on without setting them out in the words complained of would be notorious facts. For instance, if the commentator is commenting on facts which are notorious to the public by reason of the fact that, for instance, newspapers have been writing articles, for instance, about the BP oil spillage, if there's an article which lambasts the chief executive of BP, then clearly it's going to be pretty obvious why the executive is being lambasted in those terms. And the reader can think, well, it's because of the oil spillage, I've been reading about that. Well, maybe it's an accident, or maybe BP haven't handled it properly. But the reader, again, is in a position to evaluate the opinion. And the last category of facts, if you like, are where facts are unknown to the reader. Where facts are wholly unknown to the reader is relying on the commentator to give a reasonable summary of the facts upon which the commentator is commenting.
Is that putting it perhaps a bit wide, where the facts are not in the public domain? Because the facts of the play won't be known to the reader.
Well, but the play is the plays, books, films. Really, it's conceptually different because you're just talking about something that someone's put before the public for judgment. Whereas, for instance, in the case of the facts on which we're before the court today, you're dealing with three private individuals, the claimants, who've got this band where they play at weddings and so forth. If the website had said, we've got rid of them because they're terrible singers and they can't dance, then there would be a rock-solid fair comment defence, because clearly they put themselves before the public in that sense, and people probably will have never seen them perform, and most definitely probably would never employ them to perform in the future, therefore won't be able to evaluate the facts themselves. But if you take this case about a private factual dispute between the defendants and the claimants, the reader will know nothing of the facts behind that dispute, apart from what the reader reads on the website. And in this case, we say that there needs to be a reasonable summary of the facts so that the reader can evaluate the comment that's being passed on the claimants. And not to include that is not to act fairly, in the sense that the fair comment defence is not only about honesty, it's also about fairness. And that's particularly the case in this instance, because one can see that the defendant really had his own monopoly on truth. He decided what went into the website. He decided what evidence he would select to put in there and what evidence he wouldn't put in there. And the reader has got no means of finding out information to the contrary and information as to what the dispute was really about. And the claimants have got no way of defending themselves because this material is being published on the website. People are going to that website, making decisions as to who to book for their weddings, seeing that information and no doubt deciding not to book the act. But they're making that decision in blinkers. If the defendant is to be given his license to defame, he must at least set out the basis upon which he reached the conclusions set out in the comment complained of. Now, if Lord Nichols's analysis is followed, and the 5 rules he set out there are simple rules, and we say an almost comprehensive summary of the law of fair comment, then really everything else falls into place. One need not worry whether the commentator has facts in his mind or not, because that's covered in each category. All the commentator needs to do is remember that he'd actually commented on a play, and clearly that would be an easy process to fulfil because the play will be referred to in the words complained of.
So, applying this to the present case, what do you say should have been included? I mean, leave aside the false statement, but positively, what do you say should have been included which we don't find? Take the Bibis contract, for example.
Yes,
what should have been put in there?
And for instance, one's got to look at the mechanics of the fact this was a website. It would have been quite simple to put the 2 emails, the one that went from the first defendant to the first claimant, saying, we're going to sue you, we're instructing our legal team, and we're reporting you to the Musicians' Union over the breach of the re-engagement clause. I think that's 3 or 4 paragraphs long. And then put in, or at least accurately summarise, the email which truly said your contract holds no water in legal terms, because particularly from that email, the reader would have known, it would have been crystal clear that the intention of the claimants was to honour bookings with clients, regardless of the private contractual dispute they were having with the defendants. Or even if the words complained of had made it clear that there's a dispute about a re-engagement clause between the claimants and the defendant. That would have caused the reader, assuming the comment was still included in the same terms, just think, well, that seems a bit unfair, doesn't it? To reach that conclusion from that flimsy factual basis. But at the very least, the reader won't think, by reason of the evidence set out in the words complained of, that these people never abide by contracts, so we simply won't instruct them to play at our wedding at all.
Supposing not this case, but supposing just another case, somebody said, this group have repeatedly broken their contract with us, and we've decided to terminate it, and you've been well advised to think before booking these people. Would they need to say anything more than that? Would they have to specify all the times that the breaches has occurred?
Well, as long as that's an accurate and not a misleading summary of the facts.
Assuming that
it's possible.
Let me take this very case and just look at what we said and assume that they had said the first sentence, shares enjoyable, etc. However, they have breached our contract. Omit the next sentence. For this reason, it may follow that, etc., 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 to the end. Is that all right?
Well, the fair comment defence becomes pleadable at that stage. It's all right. It's leading the reader into the right direction rather than in the wrong direction. I mean, if
the wrong direction is then just simply you're returning to the misleading misquotation, you say. That's the only wrong direction, isn't it?
Well, with all due respect, you're the only wrong direction. It's a fundamental part of the words complained of, but there's nothing there leading the reader in the right direction, which is just some description, however brief, of a private contractual dispute between an agent and an artist.
But how can they, the difficulty I have with certainly the second sentence of paragraph 19 of Lord Nichols, the reader or hearer should be in a position to judge for himself how far the comment was well-founded. I mean, how can the reader judge whether it's well-founded unless he's told in great detail what the nature of the dispute is in order to, I mean, Lord Nichols can't have intended that the reader should be provided with sufficient information to enable the reader to decide whether or not in an alleged breach of contract case the allegation is or is not a good one, surely.
Well, yes, that's quite complicated, but on these facts, the facts in this case are quite simple.
But I mean, does it mean then that it's in a simple case enough should be provided to enable the reader to judge for himself, but in a complicated case that's not necessary, and that doesn't seem a principled basis.
There must be a reasonable summary of the facts. If it's not a play, a book or a film, category 1, if the facts aren't notorious to the public and one falls into category 3 and the facts are actually unknown to the reader, there must be some, to give this license to defame, which is only subject to the honest person test, there must be some fairness to protect both the claimant and to allow the reader to know what's being commented on.
But the ultimate protection surely is that the commentator will have to prove the facts upon, or subject to section 6, enough of the facts upon which the comment is based in order to get home.
But my lord, that does nothing to protect the proper reputational right of the claimant. The damage has been done. I take this example, if you have the words complained of, which set out an absolutely compelling fact which supports the comment. Now, the readers will read that and conclude the comment is well-founded. We say it's wrong as a matter of principle, that the commentator, the defendant, can then come to court, say, oh, well, forget the compelling fact that was in the words complained of, and just look at these rather less compelling facts, but nevertheless which are facts which an honest person could have reached that conclusion on.
The problem is that the comment is ex hypothesi defamatory, i.e. objectively it's not justified by the underlying fact. It's a comment a fair comment because your bigoted, biased, but honest individual might have based that comment on the fact. But if you only hear the comment and you don't know the fact upon which it's based, you're in no position to evaluate the strength to be given to the comment.
Yes.
But Lord Nichols, I mean, it's ironic, isn't it? He starts off saying, I'll set out some non-controversial matters about the ingredients of this defence that are well established. And he sets them all out, and he obviously gets paragraph 19 from somewhere, and it seems likely he got it out of the current edition of Gatley, where Lord Porter was quoted as saying that once you've identified the conduct, the defendant enables his readers to judge for themselves how far his opinion is well-founded. And therefore, what would otherwise be an allegation of fact becomes merely a comment. So it looks rather as though Lord Nichols thought this was absolutely accepted.
Yes.
And put it in as paragraph 19.
Yes.
It's not as though he resolved an issue that had been fought out with the kind of reference to authority that we have enjoyed over the last day or so.
I might be able to show you some authority which does support what Lord Nichols said. But if
Lord Porter was approving that
statement. It's not a bad one.
He doesn't go so far as to say it's a necessity. He says the reason why you identify is, he doesn't even say the reason why you must identify. He says the benefit of identification is that enables the reader to evaluate the weight to be given to the comment.
Yes. And we don't go we support Lord Nichols. What we're saying is that the reader needs to have some ability to evaluate the gap between the fact and the comment. And that's all we say. And if one adopts that rule, it has a wonderful symmetry, because on the one hand, the comment might be highly defamatory of the claimant, and the claimant will feel aggrieved by that. But if the words complain have also set out the comment, for instance, the anti-immigration speech, from which the commentator concludes that the MP is a racist, well then if the MP looks at it and thinks, well, I am actually extremely upset that I've been called a racist, but I do trust the ordinary person in reading that article to conclude that, well, that's why the commentator reached the conclusion. So in a way, the more wide the gap between the fact and the comment, potentially the greater unfairness, but as long as the fact is within the words complained of, then the reader can evaluate it properly. And the claimant doesn't really need to come to court to seek vindication, because the case has properly been put before the readership of the relevant article. Well, really, what I've been trying to develop as an argument, the effect that the Nichols test is in fact necessary because the fair comment defence is so strong, because the comment can be based on pretty much any fact, so long as the commentator honestly believes the conclusion he's reached from that fact. And just to give you an example of the breadth of the fair comment defence and the strength of the honest person test, and as said in paragraph 26 of Mr. Price's skeleton argument, in talking about...
what are we looking at? Paragraph 26?
Well, my lord, I can just read it out to you. It's not... Well, if you like to go to it, it's... will be in the core bundle.
Yeah, paragraph 26. You say?
Yes.
Mr. Price's case.
No.
If I could just ask you to read that. Well, I'll read it out. This is an extremely low hurdle for a defendant to surmount. This is particularly so at the interim stage, where the issue is whether a reasonable jury could properly conclude that an honest person could not hold the relevant opinion. As the Fawkes Committee recognised, it's the latitude given to the notional honest person test to express unfair and unreasonable opinions which enables the defence to perform its role as a bulwark of free speech. People can honestly believe many things on a very scant factual basis, without any form of rational thought, particularly if they are prejudiced or obstinate, as they are entitled to be. And we say simply that when the fair comment defence needs to provide for the fact that comments will often be made in reasonable terms in newspapers or on websites or wherever, but which are made on a scant factual basis. In order, quite reasonably, to protect the claimant's reputational rights, the fact that there is a scant factual basis has to be set out, summarised, in the words complained of, so that the public is properly informed and the claimant's reputation isn't improperly and unfairly diminished.
Well, it's a question of balancing.
Yes.
Balances, isn't it? You can't have a perfect world. If you're going to allow the bigoted, biased, but honest commentator to make a thoroughly defamatory comment about somebody, it's a matter of policy as to what preconditions do you impose before he can do that with impunity. And it's a matter of policy. You say, well, one of the preconditions is he's got to make it quite plain what the factual basis of his comment is.
Yes.
If he's going to be able to make a thoroughly defamatory comment.
Yes.
Now, the fact that he says, I'm basing all of this on what I read in the Daily Express, doesn't mean that the reader who doesn't read the Daily Express is necessarily going to be in a position to evaluate the weight to be given to the comment, but it goes some way towards redressing the balance.
It's really one of the points which Mr. Caldecott concluded with. One of the factors you might bear in mind is that the reader, if the reader were that way inclined, could go and find the supporting facts because they're in another newspaper, or, for instance, because the commentator is clearly talking about something that's notorious, the reader might go and do some research himself, which might be just going on his computer and looking up some other articles to see what the commentator is actually talking about. But again, that's a world away from the facts before this court.
I'm getting a bit lost. You see, I understood Mr. Caldecott say, Section 6 deals with a particular problem, but it doesn't, so to speak, abrogate the common law.
No.
And so you could have something, and the defendant who wants to raise a defence fair comment say, I'm not interested in Section 6. I say that I have enough underlying fact here to be able to establish the honesty of my comment.
Yes.
And so the reader won't know any of that at all.
Well, no, not on the argument I'm putting forward.
Not on what?
On the argument that I'm putting forward on behalf of the claimants. And in a situation like that, in order for the fair comment to succeed, regardless of Section 6, there must be some indication of the factual basis on which the comment is being made.
You simply say that's what the law is.
Yes.
And that the last line and a half of Section 6 is doing no more than saying what the law of fair comment is, that you won't be prejudiced by an inaccurate statement, provided that, applying the law of fair comment, you will otherwise have a defence.
Yes.
And that law requires either that you allege in terms what the base is, or that you refer to the subject matter, query what do you mean by subject matter, of your comment.
Yes. It's really, it seems quite obvious, it's to undo the injustice of Lord Porter's absolutist stance, where he seemed to say that if you include any false fact in the words complained of, you can't rely on a fair comment defence. And clearly that would be wrong, because the false fact might actually have not go to the pith and substance of the allegation or what's really being conveyed.
But Lord Porter also says you can plead 20 particulars.
Well, Lord Porter, what he is talking about there, and the judgment isn't clear in a number of respects, but what he's, on the one hand, he's saying that where it is criticism of a play or book or so forth, all one needs to do is refer to the existence of the play or the book. But on the other hand, he says that the defendant in that case, I think Tribune, in their particulars, could just plead a few particulars which showed that the Kemsley press was a low one. So really he's saying that all the defendant in that case needs to do is they might put forward 20 particulars showing why the Kemsley press is a low one. But for instance, if they can produce 3 particulars which show on certain occasions the Kemsley press behaved in a low manner, then that will enable the defence to succeed. It's odd that he says that, because elsewhere in the judgment, and the whole tenor of the judgment seems to be saying that it's just the fact of the existence of the Kemsley newspapers that need to be pleaded, as it were, in order for the fair comment defence to get off the ground.
I missed that one.
Sorry, it's what the Court of Appeal and then the House of Lords say in Kemsley is that they point to this category of fair comment, which is comment in relation to plays, books, films, and so on. And they say where the matter is put forward to the public for judgment, you don't have to rely on any underpinning facts. You don't have to set out facts in your article. And then it says that the Kemsley press or newspapers are in the same category. Therefore, it seems to suggest that all the commentator would need to do is refer to the fact that he's commentating on Kemsley newspapers. That was found to be the case in that instance, because the headline to the article was lower than Kemsley, and the ordinary person would see that in much the way that today they'd interpret an expression lower than Murdoch to be a reference to the Murdoch newspapers. But then oddly, Lord Porter, I think he might be speculating because he doesn't seem to be dealing with particulars that have actually been pleaded. He puts forward the example, well, in a case such as this, the defendant might plead 20 particulars showing that the Kemsley press is a low one. If 17 of those aren't proven, that doesn't matter, as long as he's got a couple of examples which he can prove. It's a tad inconsistent with the finding that to comment on a newspaper is of the same category as if one were commenting on a book or a film.
But I think the real point you're making is that what he's saying at page 358 is in the context of a case which falls into either your first or second of your three categories, but not a third category case.
No, absolutely.
Is that right?
Yes. It's Well, Lord, if I might return to the facts of the case.
I mean, I'm so sorry, and I won't interrupt you, but I mean, do you say that because here one has what we've been calling a false fact, so there is one fact in this communication which is not justifiable, he needs Section 6. If he was to resort only to the common law, he would necessarily fail because he doesn't have the benefit of Section 6, which says that
Yes.
you can get away with a false fact sometimes.
Yes. If I were before Lord Porter, I'd turn up on behalf of the claimant, say, there's the false fact.
That's enough.
Strike out the fair comment defence. But what Section 6 does is said, well, you can't have that one false fact and you're out. The court needs to take a more measured approach and look at the words complained of as a whole and see if there are true facts alleged or referred to which bring back the reader and make the comment a fair one.
So if you have to justify, if you have to, so to speak, get round a false fact, then you need Section 6 and you need to have everything sufficiently referred to alert the public, put it in the public.
Yes, my lord.
All right.
Returning to the facts of the case, if I briefly take you to the defence, which is at the fair comment defence is pleaded at tab 6, page 23, appendix 2. And you'll see at paragraph 10.2, the facts on which the comment is based. The defendants rely on the facts set out in paragraph 9 above, which were sufficiently identified in the page and were known to the defendants. Now, clearly there's no allegation there that any of those facts were known to the readers. And then there's a cross-reference to all of the facts which in fact support the justification defence. Now, we say that having put in the false information, the claimant cannot rescue the position by reason of the fact that there's a reference to a breach of contract and bring in these other matters, that is the landmark breach, the BB's breach, and the argument over the re-engagement term. We say that because even looking at the common law in the light of Section 6, Section 6 isn't saying that the defence still succeeds if there's a false fact, merely because there are other facts in the mind of the defendant on which the comment could have been based. The crucial word in Section 6 is in regard to facts alleged or referred to in the words complained of. there's clearly a contemplation there that what's needed is something in the words complained of, which, if you like, draws the sting which arises from the inclusion of the false fact. My Lord, in regard to freedom of speech,
I'm simply not. This is. I mean, do I understand? This is your fall. We're always in your fallback, are we here? I mean.
Sorry, I'm not talking about a fallback position.
Well, in that case, I simply don't understand. As I understand your position, it is that there is a statement, a false fact stated, upon which there then follows a comment, for this reason, blah, blah,
Yes.
blah. Now, I thought your position was that this, for this reason, was tied, and what comes after that is tied to that one statement of false fact, or that
Yes.
false fact.
Yes.
Now, if that is so, if that were so, how does anything else come in?
Well, I say it doesn't.
Well, that's what I'm saying. Is that not your fault?
But Mr. Price says it does. Therefore, I need to say it doesn't.
So that's why I'm saying, is this your fallback position? Is your primary position? None of this, there are no other facts to be considered.
Well, yes. I say you don't get to the point of looking at the landmark breach or the BB's breach or these other facts which were in the mind of the defendant. You look at the words complained of, and there is not enough there to undo the damage, the imbalance caused by the false information.
Because these other matters, you say, are not referred to in the words actually
Precisely.
used. That's your point.
It's difficult to...
And that was the finding of Lord Justice Pill, that
Yes.
this incident was too remote for any reasonable jury to reach the conclusion that that was an incident referred to in the words actually used.
Yes. It really is as simple as that. And I would say in Section 6, it's really directed to what's in the words complained of. And, sorry to labour the point, there is nothing in there which makes the comment fair. It's all very well having these other facts about things which happened 17 months before the words complained of were published, about this private contractual dispute. But the reader is given no indication of that dispute is going on in the background at all.
I'm sorry. There is one fact following a breach of contract. I mean, it is alleged there's been a breach of contract.
Yes, but that's not enough. To just looking at these words the words complained of, given the false quotation takes the reader in wholly the wrong direction by adding not only to the seriousness of the allegation, but also to the credence which would be given to the allegation. The mere reference to a breach of contract, and it's not even said which party is alleged to be in the wrong, simply is not enough to lead the reader back into the right direction. The reader's been thoroughly misinformed on a false basis.
What fact? What is the allegation of fact? Is there only one allegation of fact in this case?
A breach of contract. Well, there's an allegation of, the way it's set out, there's an allegation of fact as regards what was said in the email, but it's accepted that's false. Once one takes that away, the only allegation of fact which is left is a reference to a breach of contract.
Well, there's also have not been able to abide by the terms of their contract.
Well, that must be read in conjunction with a reference to a breach of contract.
That's a question for the jury, unless we rule that no reasonable jury could conclude that it refers to more than one breach. Is that right?
No, I wouldn't phrase it in that way. No reasonable jury, having read the false fact, could find that this comment was fair, in that, well, if I can put it, the reasonable reader, having seen the false information, the balance goes all in the wrong way. And that's a finding that this court can reach, because it's known, it's one of those cases where it's known this fact is in fact false.
I think the issue we're on is assuming you're right to say that the law of fair comment requires that the publication refers to facts upon which the comment is based. Do facts A, B, and C fall within those to which there is reference in the published
When you
comment?
say A, B,
Is
and
that
C,
a question? Well,
do you
I'm
mean
talking
landmark?
VAT, evasion, BB.
No, we say
that's an issue for the court, is it? As to whether those
as
are
a matter of law. I mean, we say as a matter of law and fact, we say a jury, there is no possibility of someone reading this being able to properly assess, gauge the value of the comment, because the reader would have no knowledge whatsoever of the landmark breach, the BBIS breach, and the true content of the email. Those facts were merely in the head of the writer. What matters and what is the necessary check upon the honest person test, again, is the reader needs to know what those facts are, or at least has to have an outline of those facts, so the reader can evaluate the comment.
Well, you say, as I understand, it's absolutely black and white here. There's no hint of a reference to anything other than one breach of contract, ergo antecedent breaches are not referred to in the publication.
Yes.
Now, what if there were an issue as to what precisely was being referred to in the publication? Would that be for the jury or for the judge?
What you've got to do is say, what would a reasonable person do reading this? The reasonable person is just presented with two facts, a broad reference to a breach of contract, and then the misquotation which suggests the claimants will not abide by contracts at all.
Why isn't that a matter for the jury?
Well, because
subject,
the jury...
subject to perversity, obviously.
Yes, subject to perversity.
Yeah.
That's ultimately, that is a jury question. But we say a jury would be perverse to evaluate it.
So you accept it is a jury question, but on the facts of this case,
Yes.
no reasonable jury could reach the conclusion other than that there's no allegation or reference.
Yes. Because the inclusion of the false quotation puts on such a different colour to the comment that the situation can't be rescued.
But Section 6 only applies if there is more than one allegation of fact.
By definition, yes.
So it only applies if you're in the situation where you've got landmark and BBIS and maybe the email or whatever it is in the frame. Because then your question is, if you fail to prove one of them, is that the end? And Section 6 says, no, it isn't, because if what's left is there, then the question is the comment fair on what is left? Is that not right?
Is the comment fair on what's set out in words complained
and what is what the defendant has proved?
The issue is what is left.
Yeah.
Is what is left.
Yeah.
Does that require reference or not? That's the issue.
Yes. And we say that you can't bring in what was in the defendant's mind about...
If he's
about
made no
facts A, B, and
reference to it
C.
in his
Yes.
publication. Yes, well, follow the submission.
My Lord, moving on, if I could deal with some of the statements made by Mr. Caldecott during his submissions yesterday.
You're going to refer us to the Court of Appeal in
What
Kempsey.
I was going to...
We haven't got to that yet.
I was going to deal with Mr. Caldecott's submissions.
All right, very well.
Unless you'd rather me
No,
proceed
you follow your
straight to
own
the
course.
authorities. What we emphasise is that the defences of justification of fair comment perform different roles and mustn't be confused. In justification defence, the facts need not be true. Sorry. In the justification defence, if the commentator sets out facts in the words complained of, which in fact aren't literally true, the defendant can still win his case in defamation, if he proves that the sting of the allegations are true. For instance, if the words complained of alleged dishonesty on one occasion, the defendant will still be able to defend himself if merely he can prove that the claimant was dishonest on another occasion. Because what's relevant is the sting complained of. So, for instance, in a justification defence, an editor of a newspaper could just accuse an MP of being a racist and then set out no facts at all. He might do so in bad faith. But if the MP then sues the editor of the newspaper for calling him a racist, the editor of the newspaper can call upon facts which exist anywhere at all to prove the sting of the libel. In fair comment, one doesn't have to prove that the comment complained of is substantially true, just that an honest person could have made it on the true facts. There will very often be no logical connection between the comment and the fact on which it's based. And if I could ask you to consider this example, if one imagines a spectrum, a straight line from your extreme left to Lambeth Palace, if on that side of the court one has the allegation complained of, then on the spectrum, the facts which would support the sting of the words complained of would be in this room, would be very close to the defamatory allegation. But in order for a fair comment defence to succeed, the facts could be on wholly the other end of the spectrum, which would probably end at someone like Lambeth Palace, because there's no logical connection. Now,
I think you've lost me at that point.
Well, again, what I'm trying to emphasise, my Lord, and I apologise for not doing it clearly enough, is that the reader needs to be aware of where in the spectrum the facts are in order for the comment to be fairly stated. Now, the important thing that Mr. Caldecott said, he said that if the facts which support a comment have to be set out in the words complained of, then one might have the situation where a claimant sues and the defendant is unable to establish the fair comment defence merely because supporting facts weren't sufficiently referred to in the words complained of. Now, Mr. Caldecott said in that case, the claimant would gain vindication on a false basis. And we say that amounts to a fundamental misunderstanding of the fair comment defence, because a claimant would only unfairly be vindicated if the defendant could not prove the allegation to be substantially true. Taking Mr. Caldecott's example, if the fair comment defence fails because the fact isn't set out in the words complained of, one isn't getting unfair vindication, because it might well be that the fact that wasn't set out in the words complained of did not and could not prove the allegation to be substantially true. Well, perhaps I could leave it on that note and then move to the authorities.
I mean, just
after
assume,
lunch.
instead of there being one landmark incident, whatever, 17 months earlier, there'd been half a dozen of them in the period up to this exchange, okay. But that it wasn't, they weren't mentioned as such. I mean, assume you're right in saying that there isn't anything enough in this email, in this, whatever it is, posting on the web, whatever that may be, to indicate that that's being relied upon, right?
Yes.
On the face of it, you would say, well, then they can't justify this comment, the comment being admitted to be this artist's obligations for your booking may not be met. But then why wouldn't that be a wrongful vindication?
Well, it would be a wrongful vindication, because in that instance, the defendant could plead justification.
Justification of what?
Well,
Justification of the comment that your bookings may not be met?
Yes, on the basis that there have been 6 breaches of contract. If there have been 6 breaches of contract, That rather suggests in the future
So
that the claimant would do it again, and that's
any
where
comment
justification.
that is sought to be justified under the defence of fair comment or honest observation is capable of being defended in the first instance by a plea of justification. Is that the position?
Where there are supporting facts, the law of defamation will protect a defendant because it provides the defence of justification.
So you only need the defence of fair comment, this is pretty elementary, you only need the defence of fair comment when you have ex hypothesi an factually unjustifiable comment.
Yes, it's one that an honest person could make, but not one that a court of law would find was substantially true based on the relevant facts.
Couldn't fairly be based upon the facts, but this is the trouble with the use of the word fair comment, because fair comment only applies to unfair comments.
Yes.
But,
well, fair, it's just always fair if the reader has an indication of what the facts are. It's fair to the...
It's fairer. It's if you say something that's defamatory, make a defamatory comment about someone, it won't take all the sting out of it if you say, I'm basing my comment on something that happened last week that's in the public domain, so far as readers who are not aware of what was in the public domain and aren't sufficiently interested to go and find out.
Yes.
It won't take all the sting out of it, but it will help.
Yes, it's the slings and arrows. It's something a claimant has to just has to put up with in order that there can be public debate on these issues. My lord, if I might stop there.
Thank you. 2 o'clock.